I am Leonard French, for the second time around, your favorite copyright attorney, standing in front of 1,500 gallons of crystal clear, spring-fed Delaware Water Gap tap water from here in sunny Bethlehem, Pennsylvania, where I have rented a dunk tank for your viewing pleasure. Figured you guys deserve a little something every once in a while, right? Well, I also have an ulterior motive here that I'm holding in my hands. I have 41 pages of Judge Amit Mehta's decision in Donald J. Trump versus the Committee on Oversight and Reform of the U.S. House of Representatives. This is the Trump tax subpoena situation, and I thought, how better to get you to pay attention to 41 pages or 90 minutes of intense material than to have you paying attention to me about to get dunked up there. So I'll leave it to my staff to tell you what the conditions are for dunking. I think it's something like an accumulative donation or something every $100 or something like that. They will pull a cord and I will unexpectedly, without warning, get dunked into the 1,500 gallon, 200 cubic foot container of water that is behind me. Actually, do we want to fill up? Yeah, no, it's too late. We're not going to fill it up with any more water. Maybe maybe somebody will fix that later as it empties out as we get dunked. We have set up 4 camera angles. If maybe they would like to show you the 4 different camera angles that we've got going right now. There is one on me here, there's a wide shot, there's a shot that we can move around, and then we've got an action camera here so you can watch me get dunked. Now, we don't have an instant replay machine. We're not a high budget production like that, so maybe this will just be the first of many Dunk-a-Lawyer challenges and stories and events that we do here. And if you guys would like to see us use an instant replay machine next time, then just let us know and maybe donate enough money for them, since they're about, what, $600 for a simple one? Yeah, so that's also why we don't have a pitching machine today. We were going to set it up so that as you donate, balls get pitched at the thing via a pitching machine, but they are also quite expensive, and we apparently don't rent them in this area. So, without further ado, are we ready? We have the thumbs up, we are ready. I'm going to go climb into the dunk tank with no further whatever and read this opinion, and we'll get through this together. If there's glitches along the way, well, guess what? We get to get through it together. We've already had audio glitches and sync glitches and color glitches, and there's bugs now. And somebody says there's a storm coming. There's a storm coming from Ohio, right? So we've got to get on this. So without further ado. You know that's going to happen once, right? Oh, would you like to come take my lavalier microphone? Thank you, sir. And that means I'm not wearing any electronics. And we'll get started. So this is in the United States District Court for the Southern District of Columbia. No, the Southern District of Columbia? No, it's just the regular District of Columbia. There's only one of them. This is Donald Trump, plaintiff, versus the Committee on Oversight and Reform of the U.S. House of Representatives. And this is the opinion that was released on May 20th. It begins with an introduction, a quote from President James Buchanan, from the Works of James Buchanan, Volume 7, 1911. I do therefore solemnly protest against the proceedings of the House of Representatives, because they are in violation of the rights of the coordinate executive branch of the government and subversive of its constitutional independence, because they are calculated to foster a band of interested parasites and informers, ever ready for their own advantage to swear before ex parte committees to pretend private conversations between President and themselves, incapable from their nature of being disproved, thus furnishing material for harassing him, degrading him in the eyes of the country. These words, written by President James Buchanan in March 1860, protested a resolution adopted by the U.S. House of Representatives to form a committee known as the Kavod Committee to investigate whether the President or any other officer of the executive branch had sought to influence the actions of Congress by improper means. Buchanan cheerfully admitted that the House of Representatives had the authority to make inquiries incident to their legislative duties, as necessary to enable them to discover and to provide the appropriate legislative remedies for any abuses which may be ascertained. But he objected to the Kavod Committee's investigation of his conduct. He maintained that the House of Representatives possessed no general powers to investigate him, except when sitting as an impeaching body. Buchanan feared that, if the House were to exercise such authority, it would establish a precedent dangerous and embarrassing to all my successors, to whatever political party they might be attached. Some 160 years later, President Donald J. Trump has taken up the fight of his predecessor. On April 5, 2019, the Committee on Oversight and Reform of the House of Representatives issued a subpoena for records to Mazars USA LLP, a firm that has provided accounting services to President Trump. The subpoena called for Mazars to produce financial records and other documents related to President Trump personally, as well as various associated businesses and entities dating back to 2011. Years before he declared his candidacy for office. The decision to issue the subpoena came about after the president's former lawyer and confidant, Michael Cohen, testified before the House Oversight Committee that the president routinely would alter the estimated value of his assets and liabilities on financial statements, depending on the purpose for which a statement was needed. For instance, Cohen said that the president provided inflated financial statements to a bank to obtain a loan to purchase a National Football League franchise. But when it came time to calculate his real estate taxes, the president would deflate the value of certain assets. To support his accusations, Cohen produced financial statements from 2011, 12, and 13, at least 2 of which were prepared by Mazars. Echoing the protests of President Buchanan, President Trump and his associated entities are before this court, claiming that the Oversight Committee's subpoena to Mazars exceeds the committee's constitutional power to conduct investigations. The president argues that there is no legislative purpose for the subpoena. The Oversight Committee's true motive, the president insists, is to collect personal information about him solely for political advantage. He asks the court to declare the Mazars subpoena invalid and unenforceable. How are we doing? Now give me like an audio, like how many people are watching? I want to make sure that we got the restart of the stream working properly, because no one who had that link will know to go to the new stream unless we tell them. One person? Courts have grappled.
We're doing good. We're doing good. We have 250 people watching. And don't tell him this, but we have $40.
Judicial decisions is that courts must presume Congress is acting in furtherance of its constitutional responsibility to legislate, and must defer to congressional judgments about what Congress needs to carry out. Okay, cool. To carry out that purpose. To be sure, there are limits on Congress's investigative authority. But those limits do not substantially constrain Congress. So long as Congress investigates on a subject matter on which legislation could be had, Congress acts as contemplated by Article 1 of the Constitution. Applying these principles here compels the conclusion that President Trump cannot block the subpoena to Mazars. According to the Oversight Committee, it believes that the requested records will aid its consideration of strengthening ethics. There we go. Whew. Now I feel better. I was waiting for that. It was freaking hot. Good job. You okay? All right. Is that the wind? All right. I feel much better now. That was some gust of wind, too. All right. But those limits do not substantially constrain Congress. So long as Congress investigates on a subject matter on which legislation could be had, Congress acts as contemplated by Article 1 of the Constitution. Applying those principles here compels the conclusion that President Trump cannot block the subpoena to Mazars. According to the Oversight Committee, it believes that the requested records will aid its conversation of strengthening ethics and disclosure laws, as well as amending the penalties for violating such laws. The committee also says that records will assist in monitoring the president's compliance with the foreign emoluments clauses. These are facially valid legislative purposes, and it is not for the court to question whether the committee's actions are truly motivated by political considerations. Accordingly, the court will enter judgment in favor of the Oversight Committee. Background. The 116th Congress and the House Oversight Committee. On January 3, 2019, the 116th Congress began with the Democratic Party controlling a majority of the seats of the House of Representatives. One of the House's first actions was to adopt the rules of the House of Representatives, which govern proceedings during the two-year term. The vote took place January 9, 2019. Rule 10 of the adopted rules, titled Organization of the Committees, establishes various standing committees and their respective jurisdictions. Among the standing committees with the broadest purview is the Committee on Oversight and Reform. Hereinafter, the Oversight... Whew. Thank you. That went up my nose. All right. Why, you got a big smile on your face. Oh.
284.
Its subject areas of primary jurisdiction range from the lofty overall economy, efficiency, and management of government operations to the mundane overall or federal paperwork reduction. If there is a common thread running through the subjects within the Oversight Committee's jurisdiction, it is the oversight of the operations and administration of the executive branch. Each of the House's standing committees possess general oversight responsibilities. Those responsibilities are meant to assist the House in 1. Its analysis, appraisal, and evaluation of the application, administration, execution, and effectiveness of federal laws. And 2, conditions and circumstances that may indicate the necessity or desirability of enacting new or additional legislation. And 3, its formulation, consideration, and enactment of changes in federal laws, such as additional legislation may be necessary or appropriate. Some of the House's standing committees have special oversight functions. The Oversight Committee is one of them. Its special oversight function is described as involving the review and study on a continuing basis the operation of government activities at all levels, including the executive office of the President. The executive office consists of a small group of federal agencies that most immediately aid the President on matters of policy, politics, administration, and management. The President's closest advisors typically are situated in the executive office. Rule 10 also vests the Oversight Committee with special authority to conduct investigations. According to the rule, the Committee on Oversight and Reform may at any time conduct investigations of any matter without regard to other rules, conferring jurisdiction over the matter to another standing committee. In other words, the Oversight Committee is empowered to investigate any subject matter, even in those areas that are expressly assigned to other committees. No other committee possesses such sweeping investigative authority. The Oversight Committee's broad investigative power is not new. in each of the 4 preceding Congresses, all of which were controlled by the Republican Party, including during the final 6 years of the Obama administration, the House Oversight Committee enjoyed the same power at any time to conduct investigations of any matter.
I have some people to read.
From the start of the 116th Congress, the Oversight Committee, now led by a Democrat, moved aggressively to use...
All right.
Thank you, sir. May I have another?
Tell him I have some big donations for him to read. We
Go
have
for it.
$150 from Kaylee. You'll have to read them back to him.
Oh my god, the dunking does not get old.
Oh, thank you, Kaylee. Oh, am I supposed to read that, or are you reading it? Oh, I'm supposed to say thank you for the $150 donation from Kaylee. Excellent. I'm assuming that's my Kaylee.
$50 from Aspernari.
It did not adopt a resolution or issue a public statement defining the scope of what it intended to investigate. Instead, it sent a series of letters to the White House and elsewhere seeking various records regarding the president's personal finances, as well as records concerning his businesses and related entities. For instance, days before the new Congress started, the incoming chairman of the Oversight Committee, Elijah Cummings, wrote the president's personal lawyer, Sherry Dillon, and the executive vice president and chief compliance counsel, George Soriel, asking them to produce previously requested documents regarding the Trump organization's process for identifying payments from foreign governments and foreign government-controlled entities. And that's, as a footnote. In a different letter, the chairman asked the General Services Administration, the GSA, the agency that manages federally owned and leased buildings, to produce records concerning the federal government's lease of the Trump organization for the old post office building, which houses the Trump International Hotel in Washington, D.C. Chairman Cummings indicated that he sought these records for multiple reasons, including the concern that the lease might violate the Constitution's emoluments clauses. There are but 2 examples. These are but 2 examples of the types of records requests made by the Oversight Committee at the start of the 116th Congress. The investigative demand that sparked this lawsuit was issued on January 8, 2019. On that day, Chairman Cummings wrote to Pat Cipollone, the White House counsel, asking the president to produce documents related to President Trump's reporting of debts and payments to his personal attorney, Michael Cohen, to silence women alleging extramarital affairs with the president before the election. The prior year, in May 2018, the Office of Government Ethics had concluded that the president should have disclosed a payment made by Cohen as a liability on the president's public financial disclosure report. The chairman noted in the January 8th letter that the Oversight Committee has jurisdiction over a wide range of matters, including the Ethics in Government Act of 1978, a law that requires all federal officials, including the president, to publicly disclose financial liabilities that could impact their decision-making. On February 1st, 2019, White House counsel responded...
I heard that.
Well, I didn't see that one coming. There's water coming out of my sleeve. And that was $50 from Aspernari. Thank you very much, Aspernari. I know you were looking forward to this. All right, I was on the word responded. I got that part.
Really quick before he starts again,
I think it was on the previous page.
We can still hear ourselves on stream, and I
on February 1st, 2019, the White House counsel responded to Chairman Cummings that the president was prepared to consider making some documents available for review. Chairman Cummings wrote the White House counsel again February 15th, 2019. I think I'm losing my tie. If I could grab the right part of the tie. There we go. He stated that by his January 8th letter, the committee launched an investigation into the failure of President Donald Trump to report hundreds of thousands of dollars in payments and liabilities to his former attorney, Michael Cohen, to silence women alleging extramarital affairs during the 2016 presidential campaign. He explained that the committee's interest in obtaining these documents is even more critical in light of new documents obtained by the committee from the Office of Government Ethics that describe false information provided by lawyers representing President Trump. The letter went on to detail a timeline of recent events, starting with statements made by the president's lawyers to the Office of Government Ethics and to the public about a supposed purpose of the Cohen payments unrelated to the election. Followed by the president's disclosure of the Cohen payments on his 2017 financial disclosure form as a liability of less than $250,000, and then revelations by federal prosecutors that the Cohen payments in fact exceeded the $250,000 reported by the president. In the end, Chairman Cummings cited Congress's plenary authority to legislate and conduct oversight regarding compliance with ethics laws and regulations as the source of its authority to make the records demand, as well as its broad authority to legislate and conduct oversight on issues involving campaign finance. On February 27th, then, Michael Cohen appeared before a public hearing before the House Oversight Committee. By this time, Cohen had pled guilty to a host of federal felony charges, including tax evasion, campaign finance violations, and making false statements to Congress. During his testimony, Cohen alleged that financial statements prepared by the president's accountants falsely represented the president's assets and liabilities. Specifically, Cohen stated that in his experience, Mr. Trump inflated his total assets when it served his purposes and deflated his assets to reduce his real estate taxes. Cohen supplied the Oversight Committee with portions of the president's statements of financial condition from 2011, 12, and 13, some of which were signed by Mazars. Following Cohen's testimony, Chairman Cummings wrote to Mazars on March 20th. The first letter summarized aspects of Cohen's testimony, accusing the president of manipulating financial statements to suit his purposes. It then identified a half-dozen questions about assets and liabilities reflected in the president's statements of financial condition that Cohen had provided to the House Oversight Committee. Cummings stated that these financial statements raise questions about the president's representations of his financial affairs on these forms and other disclosures, particularly relating to the president's debts. The letter concluded by asking Mazars to produce 4 categories of documents with respect to not just the president, but also several affiliated organizations and entities, including the Trump Organization, the Donald J. Trump Revocable Trust, the Trump Foundation, and the Trump Old Post Office. The records requested included statements of financial condition, audited financial statements, documents relied upon to prepare any financial statements, engagement agreements, communications between Mazars and the president or employees of the Trump Organization. The relevant time period identified was January 1st, 2009 to present. In his initial letter to Mazars, Chairman Cummings did not... You got a big smile on his face every time he does that. You guys are funny. Yeah, see? Give it up. All right. All right. Where were we? Thank you to Whiskers. Whiskers Cat, $50. Thank you very much for your donation. A week later, March 27th, Mazars responded that it cannot voluntarily turn over documents sought in the request. Mazars cited various federal and state regulations and professional codes of conduct that prevented it from doing so. April 12th, this year, Chairman Cummings distributed a memorandum to members of the House Oversight Committee Didn't even get through one page. $50, Trump time to dunk. Thank you very much. Trump time to dunk. The records requested. No, we went past that already. Chairman Cummings distributed a memorandum advising them of his intent to issue a subpoena. Under the section titled Need for Subpoena, Chairman Cummings cited to Cohen's testimony that the president had altered the estimated value of his assets and liabilities on financial statements, as well as to the records Cohen had provided to support these claims. He also referenced the recent news reports raising additional concerns regarding the president's financial statements and representations. In the conclusion section of the memorandum, Chairman Cummings listed the purposes for seeking the Mazars held records. Quote, "The committee has full authority to investigate whether the president may have engaged in illegal conduct before or during his tenure in office, to determine whether he has undisclosed conflicts of interest that may impair his ability to make impartial policy decisions, to assess whether he is complying with the emoluments clauses of the Constitution, to review whether he has accurately reported his finances to the Office of Government Ethics and other entities. The committee's interest in these matters informs its review of multiple laws and legislative proposals under our jurisdiction, and to suggest otherwise is both inaccurate and contrary to the core mission of the committee to serve as an independent check on the executive branch." Cummings allowed 48 hours for members to offer their views and then issued the subpoena. Notwithstanding the ranking member... Right up my nose. Why are we dunking you? Okay, let me reset, and then I'll tell you why you're dunking me. You're dunking me because this is a very important legal document. This explains the separation of powers and checks and balances between the three branches of the government, especially the President of the United States, and the ability of the House Oversight Committee, and Senate for that matter, to investigate and act as a check or balance on presidential authority. The three branches of government are meant to work together to govern the people, and if something is going wrong with one of them, the other two should have authority to act as a check or enforcement of the rule of law. Notwithstanding the ranking member's objection, on April 15th, the Oversight Committee issued the subpoena to Mazars that is the subject of this lawsuit. The subpoena sought the same 4 categories of records as identified in the March 20th letter we read before. However, it differed in one important respect. It narrowed the relevant time period by 2 years to include calendar years 2011 through 2018, instead of 2009 through 18. Plaintiffs seek injunctive relief. April 22nd, President Trump, along with his affiliated organizations and entities, filed this lawsuit. They originally named as defendants Chairman Cummings, Peter Kenny, the Chief Investigative Counsel of the Oversight Committee, and Mazars. Plaintiffs asked the court, among other things, to declare that the Oversight Committee's subpoena is invalid and unenforceable, and to issue a permanent injunction quashing Chairman Cummings' subpoena. With their complaint, plaintiffs filed an application for a temporary restraining order and motion for a preliminary injunction. Hey, we know what that's like. We did that in the Imagos Alex Mauer case. The application asked the court to enter an order prohibiting defendants from enforcing or complying with Chairman Cummings' subpoena so that the court can decide plaintiffs' motion for a preliminary injunction. Following discussions with the Oversight Committee, plaintiffs consented to the committee's intervention as a defendant on this matter and agreed to dismiss Chairman Cummings and Kenny as defendants. The parties settled on a briefing schedule on plaintiffs' motion for preliminary injunction. The Oversight Committee also agreed to postpone the date for these records request until 7 days after the court ruled on plaintiff's motion. That agreement made it unnecessary for the court to issue a temporary restraining order. Under the entered schedule, the parties were to appear May 14th, but 5 days before the hearing and 1 day after the parties had completed briefing, the court entered an order announcing its intention to consolidate the hearing on the preliminary injunction with the trial on the merits, as is permitted under the Federal Rules of Civil Procedure. Whew. Oh. Thank you, sir. May I have another? Oh, thank you, Kurt. Love you too. Oh, hey, I didn't undo one of my coattails here. It's still connected. The sole question before the court is the House Oversight Committee's issuance of the subpoena to Mazars for financial records of Donald J. Trump and various associates a valid exercise of legislative power. Is it fully briefed, and the court can discern no benefit, since it's fully briefed, from the additional round of legal arguments, nor is there an obvious need to delay ruling on the merits to allow for development of the factual record. In other words, there's no need for like a full-on separate trial after we've developed the record. We already know everything we need to know in order to make a ruling. The court made the decision to consolidate, conscious of the need to expedite these kinds of cases. In the Eastland case, the Supreme Court stated that motions to enjoin a congressional subpoena must be given the most expeditious treatment by district courts because one branch of government is being asked to halt the functions of a coordinate branch. The court was also cognizant of the fact that the Constitution's speech or debate clause forecloses plaintiffs from compelling discovery from the Oversight Committee, its members, or staff. Relatedly, the D.C. Circuit has recognized that evidence related to determining whether Congress has acted in its legislative capacity is likely to come largely, if not exclusively, from public sources. The court ordered the parties to submit any additional evidence to the court or lodge an objection to consolidation by May 13th. Plaintiffs protested the court's consolidation order, but the Oversight Committee did not. Plaintiffs asserted that in briefing only a motion for preliminary injunction, they were constrained in their arguments on the merits. They also maintained that they need more time to obtain additional evidence, specifically a memorandum of understanding negotiated between Chairman Cummings and a chair of a different House committee, which they believed the ranking member of the Oversight Committee would voluntarily disclose to them, and 2, communications between Mazars and the Oversight Committee. Plaintiffs did not assert that they could obtain discovery from the Oversight Committee. At the May 14th hearing, the court heard further argument from plaintiff on consolidation and overruled their objection. The court found that no additional briefing would aid in its decision-making, as the parties had comprehensively presented the issues and cited all applicable precedent. Indeed, plaintiffs could identify no new argument that they would make if given the chance to do so. To allow for plaintiffs' asserted need to gather additional evidence, the court left the record open until May 18th. Plaintiffs already had submitted some additional evidence after the consolidation order, which consisted of news reports of public statements of various members of Congress. Plaintiffs added 2 more letters from the ranking member before the record closed. The legal issues presented do not require the court to resolve any contested facts because material facts are not in dispute. Accordingly, having ordered consolidation, the court treats the parties' briefs as cross motions for summary judgment. Legal principles. Article 1 of the Constitution grants Congress all legislative powers. Although Article 1 does not say so expressly, the power to secure needed information has long been treated as an attribute of the power to legislate. As the Supreme Court observed in Negrey, the power to investigate is deeply rooted in the nation's history. It was so regarded in the British Parliament and in the colonial legislatures before the American Revolution, and a like view has prevailed and been carried into effect in both houses of Congress and in most of the state legislatures. There can be no doubt as to the power of Congress, by itself or through its committees, to investigate matters and conditions relating to contemplated legislation. Related to Congress's legislative function is its informing function. The Supreme Court has understood that function to permit Congress to inquire into and publicize corruption, maladministration, and inefficiency in agencies of the government. From the earliest times in history, the Congress has assiduously performed an informing function of this nature. The informing function finds its roots in the scholarship of President Woodrow Wilson, which the court first cited in United States v. Rumley. Quote, "It is the proper duty of a representative body to look diligently into every affair of government and to talk much about what it sees. It is meant to be the eyes and the voice and to embody the wisdom and will of its constituents. Unless Congress have and use every means of acquainting itself with the acts and the disposition of the administrative agents of the government, the country must be helpless to learn how it is being served, and unless Congress both scrutinize these things and sift them by every form of discussion, the country must remain in embarrassing, crippling ignorance of the very affairs which it is most important that it should understand and direct. The informing function..." Are we having fun yet? Did you do that? Or did that happen by accident? And my pages got ripped off. Ah! Oh well. Did you do it the second time? Did you mean to do that a second time? Where are we? You got $1,000 for that? Oh my god.
About 1,000 total.
Oh, cool. 1,000 total. Nice. Oh. All right. I don't remember which page we were on. In furtherance of these duties, Congress' power to investigate is broad. It encompasses inquiries concerning the administration of existing laws, as well as proposed or possibly needed statutes. It includes surveys of defects in our social, economic, or political system for the purpose of enabling the Congress to remedy them. In short, the scope of the political inquiry is as penetrating and far-reaching as the potential power to enact and appropriate under the Constitution. But Congress's investigatory power is not unbounded. The Constitution's very structure puts limits on it. For instance, the power to investigate may not extend to an area in which Congress is forbidden to legislate. Nor may Congress trench upon executive or judicial prerogatives. A prime example of such overreach is exercising the powers of law enforcement. Those powers are assigned under our Constitution to the executive and the judiciary. The Supreme Court has recognized other limits. The Congress cannot inquire into private affairs unrelated to a valid legislative purpose, nor is there a congressional power to expose for the sake of exposure. The public is, of course, entitled to be informed concerning the workings of its government. That cannot be inflated into a general power to expose, where the predominant result can only be an invasion of the private rights of individuals. When a court is asked to decide whether Congress has used its investigative power improperly, its analysis must be highly deferential to the legislative branch. A number of guideposts mark the way forward. To start, the court must proceed from the assumption that the action of the legislative body was with a legitimate object, if it is capable of being so construed. And the court has no right to assume that the contrary was intended. It also must presume that the committees of Congress will exercise their powers responsibly and with due regard for the rights of affected parties. So, when it appears the Congress is investigating on a subject matter in the aid of legislating, the presumption should be indulged that this was the real object. An important corollary to this presumption of regularity is that the courts may not test the motives of committee members to negate an otherwise facially valid legislative purpose. Our cases make clear that in determining the legitimacy of a congressional act, we do not look to the motives alleged to have prompted it. So long as Congress acts in pursuance of its constitutional power, the judiciary lacks authority to intervene on the basis of the motives which spurred the exercise of that power. Cass! Thank you, Cass! Man, I'm gonna sleep well tonight. I was on here someplace. Thus, it is not the court's role to decipher whether Congress's true purpose in pursuing an investigation is to aid legislation or something more sinister, such as exacting political retribution. If there is some discernible legislative purpose, courts shall not impede Congress's investigative actions. Although Congress's motives are off limits, courts can consider what Congress has said publicly to decide if it has exceeded its authority. Relevant evidence includes the resolution authorizing the investigation, statements by committee members, and questions posed during hearings. At the same time, the mere absence of public statements identifying the purpose or subject matter is not by itself conclusive of an invalid purpose. Congress is not required to announce its intentions in advance. Similarly, it does not matter if the investigation does not produce legislation. The very nature of the investigative function, like any research, is that it takes the searchers up some blind alleys and into non-productive enterprises. To be a valid legislative inquiry, there need be no predictable end result. The critical inquiry, then, is not legislative certainty, but legislative potential. If the subject matter of the investigation is one on which legislation could be had, Congress acts within its legislative function. The subject of any inquiry always must be one on which legislation could be had. Once a court finds that an investigation is one upon which legislation could be had, it must not entangle itself in judgments about the investigation's scope or the evidence sought. Only an investigative demand that is plainly incompetent or irrelevant to any lawful purpose of the committee in the discharge of its duties will fail to pass muster. Importantly, in making this assessment, it is not the judicial officer's job to conduct a line-by-line review of the committee's requests. There is no requirement that every piece of information gathered in such an investigation be justified before the judiciary. And finally, courts must take care not to be swayed by the political conflicts of the day. Its role is not to act as a political referee. As the Supreme Court cautioned in Tayne v. Brandhove, in times of political passion, dishonest or vindictive motives are readily attributed to legislative conduct and as readily believed. Courts are not the place for such controversies. Self-discipline and the voters must be the ultimate reliance for discouraging or correcting such abuses. the courts should not go beyond the narrow confines of determining that a committee's inquiry may fairly be deemed within its province. Province? What the heck's going on behind me? Oh, they're setting up for something. And finally, the analysis. With these principles in mind, the court proceeds to consider whether the Oversight Committee's subpoena to Mazars is facially legislative in character, or whether it exceeds Congress's power to investigate. To answer that question, the court first considers the legislative reasons offered by the Oversight Committee to justify the subpoena. It then addresses plaintiffs' contentions why those reasons are invalid. Had the Oversight Committee adopted a resolution that spells out the intended legislative purpose and scope of its investigation, the court would have begun its inquiry there. Thank you. From Oops. Thank you, Oops. The name is actually Oops, or that was an Oops? Okay. Thank you very much, Oops. And for reference, we are halfway through this thing, so if you want to get your dunks in, you got to do it in the next 20 pages. Halfway through. Where were we? I think I was still on the other. Indeed, the Supreme Court has considered congressional resolutions as the primary source from which to glean whether information was sought in aid of legislative function. However, the committee never adopted one. While a clearly drafted resolution would have made this court's task easier or might have preempted the challenge now brought altogether, it is not a constitutional prerequisite to start an investigation. And there's a note for you. That's the judge giving you a note. Congress. That's the judge saying, by the way, if you had adopted a resolution, we would be done by now. Without a resolution as a point of reference, the logical starting point for identifying the purpose of the subpoena is the memorandum to the members of the House Oversight Committee, the April 12, 2019 memo. Chairman Cummings penned that memorandum in anticipation of issuing the subpoena. It is therefore the best evidence of the committee's purpose. It lists the 4 areas of investigation. Whether the president may have engaged in illegal conduct before. Another $80 from Aspernari. Sure. What time is it now? Okay. Yeah. Whether the president may have engaged in illegal conduct before or during his tenure, whether he has undisclosed conflicts of interest that impair his ability to make impartial policy decisions, whether he is complying with the Emoluments Clause of the Constitution, and whether he has accurately reported his finances to the Office of Government Ethics. Each of these is a subject on which legislation could be had. Taking the reasons in reverse order, the accuracy of the president's financial reporting relates directly to the law that requires it. The Ethics in Government Act of 1978. In his letter to the White House counsel dated February 15th, Chairman Cummings alluded to how documents relating to the accuracy of the president's disclosures fell within the legislative purview of Congress. Since the earliest days of our republic, Congress has investigated how existing laws are being implemented and whether changes to the laws are necessary. For decades, this has included laws relating to financial disclosures required of the president. As to the specific demand made on February 15th, which relates to the payments by Michael Cohen and the president's failure to publicly report them as a liability, Chairman Cummings explained that these documents will help the committee determine why the president has failed to report these payments and whether reforms are necessary to address deficiencies within current laws, rules, and regulations. The legislative rationale applies equally to the financial records requested by the Mazars subpoena. Congress reasonably might consider those documents in connection with deciding whether to legislate on federal ethics laws and regulations. For example, the discovery of additional disclosure violations by the president could influence whether Congress strengthens public reporting requirements or enhances penalties for non-compliance. Thus, there can be little doubt that Congress's interest in the accuracy of the president's financial disclosures falls within the legislative sphere. Investigating whether the president is abiding by the Foreign Emoluments Clause is likewise a subject on which legislation or similar congressional action could be had. The Foreign Emoluments Clause prohibits the president from accepting any emolument from any king, prince, or foreign state without the consent of Congress. The Constitution thus expressly vests in Congress the unique authority to approve the president's acceptance of emoluments, however one defines that term. Even under the president's favored interpretation, the clause at a minimum was intended to combat corruption and foreign influence. Surely, incident to Congress's authority to consent to the president's receipt of emoluments is the power to investigate the president's compliance with the clause. Without such power, Congress's constitutional function to approve or disapprove emoluments would be severely and unduly constrained. The founders could not have intended that result. A congressional investigation to carry out expressly delegated Article I functions, in addition to any legislation that might be had relating to that function, is plainly valid. And there's a footnote here. To be clear, even if Congress's authority to approve the president's receipts of emoluments is technically not a legislative act, the court doubts that the Supreme Court would read its precedent to foreclose Congress from investigating an emoluments clause violation based on a semantic distinction. The fact is, no court has ever been asked to address the extent to Congress' power to police the emoluments clause. Therefore, it should come as no surprise that there is no case holding that Congress may exercise its power to investigate in relation to that clause. But just as Congress's authority to legislate is expressly rooted in Article I, so too is its power to consent to presidential receipt of emoluments. If Congress's power to investigate is incidental to its legislative function, it likewise must be incidental to carry out its Foreign Emoluments Clause function. So too is an investigation to determine whether the president... Sure.
You can just use my phone if you would.
Yeah. Hi. Oh, are we looking into that camera? Excellent. Okay, I can hear you now. Everybody can hear them, right? No, they can't be heard? No, he wants you to go switch that. Hang on, I can't hear you yet now. Your phone's waterproof, right?
Let's not test it.
All right. Can I hear you now? Yes, I can hear you. All right, so what's going on?
And I figured an hour and like halfway through the document is a good time to stop and do that. So,
Okay.
and also there's somebody
Okay, you are on stream now.
Good.
Why don't you go ahead and read them while I drip dry here?
Okay. And apparently there's somebody about to start up a lawnmower, so I think that's what John's going to take care of now. I will start with the super chats. We've had a bunch of super
Someone's
chats.
gonna go start up the lawnmower.
Yeah. So John wants to go fix that talk to him while we.
Yeah, we only need like another hour.
Yeah. Okay, so we have $5 from LOL WTF DR3. He says, "Let's go, folks. Leonard looks like he needs to cool down." We have $2 from Corey Catalano. We have $2 from Jefferson, who says, "Well, I'll donate an appropriate amount." He said we have $2 from Joe Eason. Let's dunk him to make sure it works. We have $5 from Max Mech, Dunk the Lawyer. We have $10 from Jefferson. Let's get the man to 600. You're doing my namesake proud. $1 from Shining Dialga. 5 Polish, whatever the L is, from Sebastian Jezerski. $10 from Jefferson. We shall not suffer self-appointed kings nor tyrants in our democracy. $20 from Blackleaf on Super Chat. Everybody hurts sometimes. $20 from Brian Stone. $10 from Jefferson. Dunk that man. $20 from Aspernari. We are having fun. And $10 from Clint Harden. Donation page is blocked at my work. Hope this helps. And that was just all of these Super Chats. Now I gotta switch over to my tips feed here. I have a lot of stuff to read for you.
Okay.
You have anything you want to put in before I start that?
Nope, please, go ahead.
Alright, $5 from Donald Green. Gotta dunk that on that law. $5 from Jameson Lalone. $5 from Lucas, who says beep boop. $5 from Lint, who says it's raining Len. Hallelujah, it's raining Len. $5 from David McGuire. $150 from Kaylee, who says, I wanted to get you wet. You can return the favor later. She wanted me to say it. She really wanted me to say it on stream. So,
Okay.
$5 from Anonymous. Watch me end this man's whole dryness. $5 from Casira. $10 from, oh gosh, Icumuertel. Helmin. I don't know, man. That's a really weird name. Icumuertel, I guess. And he says something in a different language. I don't know what that says. $2 from Jordan Forrester. $100 from Anonymous. He said Trump, time to dunk. $20 from Gail. $5 from an Anonymous. $10 from Heidi Sosinski. More going to the dunk tank. $5 from Donald J. Trump. Hi, YouTube. Keep up the good work. And Leonard, I love what you're doing. $5 from Anonymous. He looks thirsty. $10 from Anonymous. I salute your sacrifice, Leonard. Let's dunk you again. $20 from Shane Stacy. $50 from Aspernari. Make him fly. And then she repeated it a whole bunch of times, but it's like the Game of Thrones thing.
Make the lawyer man fly.
$10 from John Swanson. Love your channel. Keep up the great work. $10 from Snorre Wisotzky. Whatever. Take another $10, just like before. $10 from Whiskers. I think that suit needs to be cleaned again. $5 from Tyler LaPointe. Dunk a lawyer. Amazing. And then $50 from Whiskers. He was reacting to your first dunk, I think, which was responded. Which was your reaction when you got dunked.
Yes. Yep.
$10 from Anonymous. $100 from PB Warrior. He said Trump again into the drink.
Nice.
$50 from Emilius. Love your channel. Keep educating us lawful masses. $100 from Kurt Blackleaf. Paid for by the committee to re-elect President Donald Trump. I love you, Leonard. $100 from Aspernari. Get dunked, fool. $50 from Cass. $20 from Direwolf 1973. Your channel has lifted a veil that has blocked my view of many of our laws and judicial procedures. Thank you very much for your work.
Excellent.
$100 from Oops. I don't support in other ways, but this seems worth it.
All right. Excellent.
$80 from Aspernari. We're no strangers to love. It's the lyrics to Rick Astley. You know the rules, and so do I.
Never gonna give you up.
$100 from PB Warrior. Gotta get one more Duncan.
Never gonna dunk around and dunk you.
$5 from Anonymous. Dunk him! $100 from Oops. I did it again.
Cute.
And $10 from Leo. And that we are up to date as of 5 minutes ago.
Excellent. Excellent. All right, Mr. Sir, come and get your phone, and I will continue with my dramatic reading of Judge Amit Mehta's opinion of the Trump tax subpoena. So too is an investigation to determine whether the president has any conflicts of interest. As already discussed, it lies within Congress's province to legislate regarding the ethics of government officials. Indeed, exposing conflicts of interest is one of the core objectives of the Ethics in Government Act. As the D.C. Circuit has observed, the act shows Congress's general belief that public disclosure of conflicts of interest is desirable despite its cost in loss of personal privacy. Obtaining records to shed light on whether the president has undisclosed conflicts of interest is therefore entirely consistent with potential legislation in an area where Congress already has acted and made policy judgments. Finally, a congressional investigation into illegal conduct before and during the president's tenure in office fits comfortably within the broad scope of Congress's investigative powers. At a minimum, such an investigation is justified based on Congress's informing function, that is, its power to inquire into and publicize corruption. It is simply not fathomable that a constitution that grants Congress the power to remove a president for reasons including criminal behavior would deny Congress the power to investigate him for unlawful conduct, past or present, even without formally opening an impeachment inquiry. On this score, history provides a useful guide. Twice in the last 50 years, Congress has investigated a sitting president for alleged law violations before initiating impeachment proceedings. It did so in 1973 by establishing the Senate Select Committee on Presidential Campaign Activities, better known as the Watergate Committee. And it did so again in 1995 by establishing the Special Committee to investigate Whitewater Development Corporation and related matters. Hereinafter, the Whitewater Resolution. The former investigation included within its scope potential corruption by President Nixon while in office. The latter concerned alleged illegal conduct by President Clinton before his time in office. Congress plainly views itself as having sweeping authority to investigate illegal conduct of a president before and after taking office. This court is not prepared to roll back the tide of history. Before moving on, I'll get done. Before moving on to plaintiff's arguments, the court notes that the Oversight Committee has identified several pieces of actual legislation that it asserts are related to its overall investigation of the president. The House has passed H.R. 1, which requires, among other things, the President and Vice President file new financial disclosure forms within 30 days of taking office, and to divest all financial interests that would pose a conflict of interest by either converting those interests to cash or investments that satisfy ethics rules, or placing those interests in a qualified blind trust, or disclosing information about business interests. Other bills cited by the Oversight Committee include H.R. 745, which would strengthen the Office of Government Ethics, H.R. 706, which would prohibit the President and Vice President from conducting business directly with the federal government. There is no mention of any of these bills in any written request from the Oversight Committee, let alone the April 12th memorandum justifying the Mazars subpoena. That absence is not fatal, however. Again, the question for the court is whether the congressional investigation pertains to a subject matter on which legislation could be had, so Congress need not proactively identify any specific legislation to justify its activities. Here, the bills identified by the Oversight Committee demonstrate Congress's intention to legislate, at the very least, in the areas of ethics and accountability for executive branch officials, including the President. These are subjects, therefore, on which legislation could be had. Plaintiffs' contentions. Now, each of plaintiffs' arguments for why the Mazars subpoena exceeds Congress' Article 1 investigative power fall into one of three general categories. First, by characterizing the Oversight Committee's investigations into one delving into the accuracy of a private citizen's past financial statements, plaintiffs contend that the Oversight Committee is engaged in a quintessential law enforcement task reserved to the executive and judicial branches. Plaintiffs similarly contend that the investigation into the accuracy of the president's financial disclosures, his adherence to the emoluments clauses, and his present or past compliance with the law is therefore law enforcement activity that encroaches on the prerogatives of the coordinate branches. Second, plaintiffs charge that the Oversight Committee's investigation has nothing to do with government oversight, but is intended to expose, for the mere sake of exposure, the conduct of a private citizen years before he was a candidate for public office. Finally, plaintiffs maintain that the Oversight Committee has exceeded its authority insofar as it is doing nothing more than conducting roving oversight of the president, and the records sought from Mazars are not pertinent to any legitimate legislative purpose. The court will address each of these arguments in turn. Plaintiffs first assert that each of the four justifications for the Mazars subpoena identified in the April 12th memorandum falls outside the bounds of legislative power because each seeks to determine whether the president broke the law, a function reserved exclusively to the executive and judicial branches. That argument, however, rests on a false premise. Just because a congressional investigation has the potential to reveal law violations does not mean such investigation exceeds the legislative function. The Supreme Court's understanding of a legislative purpose is not so constrained. To be certain, the Supreme Court has said that the power to investigate must not be confused with any of the powers of law enforcement. Those powers are assigned under our Constitution to the executive and the judiciary. But that limitation is not so absolute as to foreclose Congress from investigating any law violation by a private citizen, let alone a sitting president. Kurt says patent law is greater than copyright law. I think it's apples and oranges, Kurt. I am draining. So long as Congress is operating with a legislative purpose, as the court explained in Sinclair v. United States, it may be conceded that Congress is without authority to compel disclosures for the purpose of aiding the prosecution of pending suits, but the authority of that body, directly or through its committees, to require pertinent disclosures in aid of its own constitutional power is not abridged because the information sought to be elicited may also be of use in such suits. Thus, the court has made clear that the mere prospect that a congressional inquiry will expose law violations does not transform a permissible legislative investigation into a forbidden executive or judicial function. Moreover, appellate courts have demanded exacting proof before declaring that Congress has impermissibly intruded into executive or judicial territories. According to the Supreme Court, to find that a committee's investigation has exceeded the bounds of legislative power, it must be obvious that there was an usurpation of functions exclusively vested in the judiciary or the executive. Therefore, a congressional investigation that seeks to uncover wrongdoing does not, without more, exceed the scope of Congress's authority. In this case, there is nothing obvious about the Oversight Committee's activities to support the conclusion that the subpoena to Mazars is an usurpation of an exclusively executive or judicial function. Nothing gives warrant for thinking the Oversight Committee is attempting to, or intending to, try the President at its bar or before its committee for any crime or wrongdoing. Nor is there any evidence before the court that the Oversight Committee initiated its investigative activities at the behest of federal or state law enforcement officials, or is coordinating its actions with such officials. If anything, the evidence is to the contrary. The executive branch is clearly not coordinating with Congress, as it continues to resist calls to disclose records relating to the President's action in areas arguably well within Congress's investigative powers. The committee's stated purpose, therefore, does not usurp judicial or executive functions. To support their position, plaintiffs point out that the Mazars subpoena arose out of the testimony of Michael Cohen, quote, an admitted perjurer. 2, the records sought related primarily to the president's personal and financial interests years before he became a candidate. And 3, Chairman Cummings admitted that the Mazars subpoena was intended to investigate whether the president may have engaged in illegal conduct before or during his tenure in office. In addition, plaintiffs cite to statements made by Chairman Cummings before he issued the Mazars subpoena. For instance, in his March 20th letter to Mazars, Chairman Cummings focused solely on Michael Cohen's allegations that President Trump misrepresented his assets and liabilities and made no mention of a legislative purpose for obtaining the records. Additionally, plaintiffs offered a November 2018 Vox article that quotes Chairman Cummings as saying, "We've got to address this issue of exposing President Trump and what he has done, and we've got to face the truth. The president is a guy who calls truth lies and lies truth. But at some point, he's also creating policy, and that's affecting people's day-to-day life." Plaintiffs also provide a Politico article in which Chairman Cummings is quoted as saying, "Over the last 2 years, President Trump set a tone from the top of his administration that behaving ethically and complying with the law is optional. We're better than that." None of these facts, individually or taken together, make for an obvious usurpation of functions exclusively vested in the judiciary or the executive. History has shown that congressionally exposed criminal conduct by the president or a high-ranking executive official can lead to legislation. The Senate Watergate Committee provides an apt example. That committee's express mandate was to investigate the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons acting either individually or in combination with others in the presidential election of 1972 or in any related campaign or canvass conducted by or on behalf of any person seeking nomination or election as the candidate for the office of president. As a consequence of the committee's work, Congress passed numerous pieces of legislation, among them the Ethics in Government Act, the Congressional Budget and Impoundment Control Act, the War Powers Resolution Act, and the Independent Counsel Statute, with objectives to open up the operation of the presidency to greater public oversight, subject the presidency to legal checks by other branches or institutions of government, and, more generally, impose rule of law principles to more and more types of presidential decision-making. The Teapot Dome scandal provides another illustration. That congressional investigation concerned the award... Way, $1,700 total. Thank you very much. That was Kurt for $47.01. Okay, 10 pages to go. I think I'm going to be ready to be done by the time this is done. I think there's a limit. There's a limit on how much of this a person can take. The Teapot Dome scandal. That congressional investigation concerned the award of a no-bid... Hang on. Of a no-bid contract to lease federal oil reserves in Wyoming. Congress's investigation revealed that the Secretary of Interior had accepted bribes from oil companies that were later awarded the leases. This discovery motivated Congress to enact several good government reforms, including the Revenue Act of 1924 and the Federal Corrupt Practices Act of 1925. This court is in no position to say that an equally ambitious legislative agenda might not arise out of the current era of congressional investigations of the presidency. Plaintiffs next accused the Oversight Committee of issuing the subpoena to Mazars simply to investigate the private affairs of a citizen. This argument fares no better than plaintiffs' first. More than a century ago, in Kilbourne versus Thompson, the Supreme Court stated that Congress does not possess the general power of making inquiry into the private affairs of a citizen. In the ensuing decades, the Supreme Court repeatedly has affirmed that constraint on Congress's investigative powers. But Kilbourne is the high watermark for that limiting principle. In the nearly 140 years since Kilbourne, neither the Supreme Court nor any circuit court has found a congressional investigation unconstitutional because it invades the private affairs of a citizen. Indeed, years later, in the context of warning courts to be very wary of declaring a congressional inquiry unconstitutional, the Supreme Court acknowledged Kilbourne's shortcomings. Quote, "Experience admonishes us to tread warily in this domain. The loose language of Kilbourne v. Thompson, the weighty criticism to which it has been subjected, Fairman, Mr. Justice Miller, and the Supreme Court, yada yada yada, strongly counsel abstention from adjudication unless no choice is left. Accordingly, although the notion from Kilbourne that the Congress does not have the general power to investigate into personal affairs remains alive today, the case is largely impotent as a guiding constitutional principle. But no standard, quote, can be developed from Kilbourne v. Thompson. Its result contradicts an unbroken..." Hello. Welcome home.
That felt so good. Breathing water, are we?
Yeah. Breathing water. Trying not to get snot on my suit. Adam Romberg. Thank you, Adam. My mom pulled that one. It looked like, right? Ah. Okay. Oh. How then to measure whether Congress has ventured into impermissible territory of investigating the personal affairs of a private citizen? The Supreme Court has provided some guidance. In Quinn, the court said that Congress cannot use its investigative power to inquire into private affairs unrelated to a valid legislative purpose. The public is, of course, entitled to be informed concerning the workings of its government. That cannot be inflated into a general power to expose where the predominant result can only be an invasion of the private rights of individuals. Thus, the question the court must ask is whether the Oversight Committee's investigation into the President's personal affairs is fully divorced from any legislative purpose. Indulging in the presumption that when Congress acts, it does so for a proper reason, the court cannot say that the records sought from Mazars are unrelated to a valid legislative purpose, or that the predominant result can only be an invasion of the President's private affairs. As discussed above, legislation could stem from the Oversight Committee's investigation of the President's personal and corporate finances and the possible conflicts of interest under which he is operating. Thus, the potential presence of some intent to ridicule, harass, or punish the President cannot overcome this facially valid legislative purpose. In their complaint and in their supplemental evidentiary submission, plaintiffs reference various statements from Democratic members of Congress and congressional aides to the effect that Democrats are intending to use their subpoena power to exact political retribution. For instance, one congressman is quoted as saying, "We are going to have to build an air traffic control tower to keep track of all the subpoenas flying here to the White House." Another Democratic official said that House Democrats were preparing to subpoena a subpoena cannon to fire at the President. Plaintiffs urge that these and similar statements reveal that the Democrats' true motive is to embarrass and harass the President, which cannot be cured by the committee's retroactive rationalizations in the April 12th memorandum. Even if the court were to take these statements at face value, at best a dubious evidentiary proposition, given that these individuals do not control the actions of the Oversight Committee, they make no material difference. The case law makes clear that motives alone would not vitiate an investigation which had been instituted by a House of Congress if that assembly's legislative purpose is being served. In Watkins, the petitioner marshaled an impressive array of evidence that some congressmen have believed that their duty was to bring down upon himself and others the violence of public reaction because of their past beliefs, expressions, and associations. This evidence did not, however, carry the day with the Supreme Court because Congress also has a legitimate legislative purpose for its investigation. Likewise, in Negrey, the court rejected a lower court's decision echoing the plaintiff's advance argument here. The extreme personal cast of the original resolutions, the spirit of hostility towards the then Attorney Generals which they breathe, that it was not avowed that legislative action was had in view until after the action of the Senate had been challenged, and that the avowal was then coupled with an avowal that the other action has in view, are calculated to create an impression that the idea of legislative action being in contemplation was an afterthought. The court there held that the lower court was wrong because the subject of the investigation was one in which legislation could be had. In short, as long as there is a facially valid legislative purpose for the investigation, Congress acts within its constitutional authority. That is the case here. For this same reason, the forceful dissenting statements of the ranking member of the Oversight Committee, Congressman Jim Jordan, we have officially we've officially killed one shoe. Thank you. DB Warriors, $100, and my dad, $50.
PB Warrior.
PB. As in like peanut butter? All right. It's for a good cause. Oh. 7. I'm starting to get cold. If you hear me shivering a little bit, that's what that is. Oh. Plaintiff's third and final challenge. Thank you very much. That's $2,000. Wow. Oh.
Nice suit.
Thank you. It might survive. The shoe might not. This was one of your old shoes from like 20 years ago that you gave to me.
My wedding shoes.
I don't know.
Doesn't say help me.
Alfani's? Were your wedding shoes Alfani's? All right. Plaintiff's third and final challenge rests on the pertinency of the requests. Or wait, we were still on the thing. I can remember, it does not change the court's calculus. Oh well, we still skip. To begin, according to plaintiffs, for the Mazar's subpoena to be valid, the records sought must be reasonably relevant to the subpoena's legitimate legislative purpose, and the records demanded fail that test. This argument suffers from two problems. The first is that plaintiffs conflate the concept of pertinency with the notion of relevancy as used in civil proceedings. Pertinency does not require the court to ask, as it would in a civil discovery dispute, whether the documents requested are likely to yield useful evidence. Instead, pertinency is a judicial concept drawn from the nature of a congressional committee's source of authority. The concept appears most often in the context of a criminal conviction for contempt of Congress, in which a person has refused to comply with a subpoena or answer questions posed at a hearing. Pertinency in this setting is an element of criminal contempt. The pertinency inquiry therefore asks whether the question posed to a witness is one that fell within the scope of the committee's investigative authority, which typically is defined by the resolution authorizing the investigation. This is not a contempt case. This is not a contempt case, and therefore the pertinency inquiry, properly understood, has no role here. But even if a court were to treat pertinency as akin to a relevancy determination, that test is satisfied here. the standard adopted by the Supreme Court is a forgiving one. The subpoenaed records need only be not plainly incompetent or irrelevant to any lawful purpose of the committee in the discharge of its duties. Here, the Oversight Committee has shown that it is not engaged in a pure fishing expedition for the president's financial records. It is undisputed that the president did not initially identify as liabilities on his public disclosure forms the payments that Michael Cohen made to alleged mistresses during the presidential campaign. Further, Michael Cohen has pleaded guilty to campaign finance violations arising from those payments. These events, when combined with Cohen's testimony and the financial statements he supplied, make it reasonable for the Oversight Committee to believe that the records sought from Mazars might reveal other financial transgressions or improprieties. As already discussed, it is not unreasonable to think that the Mazars records might assist Congress in determining whether ethics statutes or regulations need updating to strengthen executive branch accountability, promote transparency, protect against executive branch officials operating under conflicts of interest. Additionally, the Mazars records could provide the Oversight Committee with clues about the president's foreign interests or sources of foreign income, if any, which would assist in determining Congress's obligations under the Foreign Emoluments Clause. This concern is not a new one. In other letters seeking records, one sent to the Trump Organization and the other to the GSA, Chairman Cummings expressly stated that the records sought would be useful in assessing the president's compliance with the Foreign Emoluments Clause. The records from Mazars likely could advance this legislative purpose. Pertinency, to the extent it may apply, is thus satisfied. Two arguments remain. First, plaintiffs insist that the Oversight Committee cannot be seeking pertinent material because the legislative actions contemplated extend to an area in which Congress is forbidden to legislate. For example, plaintiffs argue that H.R. 1... I can't read that, hang on. Grunkle Tia Marie? Grunkle T. Rowe. All right. Thank you very much. Oh, you missed it before when he pulled me 3 times in a row. For example, plaintiffs argue that H.R. 1 is unconstitutional insofar as it adds qualifications for the presidency beyond those already contained in Article 2 of the Constitution. More broadly, plaintiffs maintain that any regulation of the president's finances or conflicts of interest would be unconstitutional for the same reason. Plaintiffs' contention flies in the face of decades of legislation covering the president. For example, the Ethics in Government Act requires the president to report the source, type, and amount of certain income and assets to the Office of Government Ethics. The Stop Trading on Congressional Knowledge Act of 2012 provides that no executive branch employee, including the president, may use non-public information derived from such person's position as a means for making private profit, and further states that executive branch employees, including the president, owe a duty arising from a relationship of trust and confidence to the United States government and the citizens of the United States with respect to material, non-public information derived from their position. And the Presidential Records Act directs the president to take all such steps as may be necessary to assure that the activities, deliberations, decisions, and policies that reflect the performance of his constitutional, statutory, and other official or ceremonial duties are adequately documented, and that such records are maintained as presidential records. Plaintiff's argument, if accepted, would wipe out some and perhaps all of these statutes. But there is an even more fundamental problem with plaintiff's position. It is not the court's role in this context to evaluate the constitutionality of proposed or contemplated legislation. Doing so would go beyond the court's limited powers. The Supreme Court said as much in Rumley. Whenever, quote, whenever constitutional limits upon the investigative power of Congress have to be drawn by the court, it ought only be done after Congress has demonstrated its full awareness of what is at stake, unequivocally authorizing by unequivocally authorizing... We're 5 pages out. All right, so we're finishing it up then. Oh, and good too, because I'm a little stuffed. I'm a little soggy, a little cold, a little wet, a little tired. The Supreme Court said as much in Rumley, quote, "Whenever constitutional limits upon the investigative power of Congress have to be drawn by the court, it ought only be done after Congress has demonstrated full awareness of what is at stake by unequivocally authorizing an inquiry of dubious limits. Experience admonishes us to tread warily in this domain. Consequently, courts must avoid declaring an investigation by Congress unconstitutional unless no choice is left. In this case, not only is there no need to confront difficult constitutional questions, it would be improper to do so. Federal courts do not render advisory opinions. For adjudication of constitutional issues, concrete legal issues presented in actual cases, not abstractions, are requisite. The court here faces only abstract constitutional questions about prospective legislation, and that is not yet defined as law. The court cannot declare a constitutional investigation unconstitutional in such ill-defined circumstances. Finally, plaintiffs suggest that the court has the authority to narrow overbroad congressional subpoenas and should consider doing so here. But the federal courts enjoy no such power. A legislative inquiry may be broad as searching and as exhaustive as is necessary to make effective the constitutional powers of Congress. There is no requirement that every piece of information gathered in such an investigation be justified before the judiciary. The courts therefore cannot engage in a line-by-line review of the Mazars subpoena and narrow its demands. This court has no authority to restrict the scope of, in the quote here, an ethics committee's investigation. Finally, the request to stay pending appeal. At the May 14th oral arguments, plaintiffs asked the court to stay the return date of the subpoena beyond the 7 days already agreed upon by the parties, pending final appellate review by the D.C. Circuit. This court declines to do so. Federal Rule Civil Procedure authorizes a district court to issue an injunction pending appeal. To obtain a stay pending appeal, the moving party must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of such relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. The court balances these factors on a sliding scale such that a strong showing on one factor would make up for weaker showings on others. As to the first factor, plaintiffs have not shown that their challenge to the Mazars subpoena presents serious legal questions going. Okay. Home stretch. Home stretch. Home stretch. Okay. Plaintiffs have not shown that their challenge to the Mazars subpoena presents serious legal questions going to the merits. So serious, substantial, or difficult as to make them fair ground of litigation and thus far more deliberative investigation. None of these three grounds upon which plaintiffs challenge the subpoena rests on potentially persuasive authority. Indeed, plaintiffs have cited no case since Kilbourne from 1880 in which the Supreme Court or the D.C. Circuit has interfered with a congressional subpoena because it either intrudes on the law, enforcement prerogatives of the executive or judicial branches, seeks personal information unrelated to the legislative purpose, or demands records that lack pertinency. This case does not merit becoming the first case in nearly 140 years. As for irreparable harm, this court does recognize that the disclosure of confidential information... Oh, you're doing that.
dunk.
That was what?
The last dunk.
That's the last dunk?
The last dunk.
Okay.
No more donation for dunks.
Okay. I'm okay though. I can keep going. I'm just a little chilly. Just a little. I'm watching you pull on that rope. As for irreparable harm, this court has recognized that the disclosure of confidential information is by its very nature irreparable because such information, once disclosed, loses its confidential nature. That concern is somewhat mitigated here, however, because of the recipient of the records. Unlike other cases where the challenge disclosure was to a market competitor, the disclosure here is made to Congress, and the D.C. Circuit has held that the courts must presume that the Committee of Congress will exercise their powers responsibly and with due regard for the rights of affected parties. That said, the court is not naive to reality, a reality confirmed by the fact that the Oversight Committee has said that the decision whether to make the records public lies within its discretion. Thus, there is a chance that some records obtained from Mazars will become public soon after they are produced. The second factor of irreparable harm thus favors a stay. The final two factors, the balance of equities and the public interest, merge when, as here, the government is the opposing party. These factors tip the balance in favor of denying a stay. In Exxon, the plaintiff had challenged Congress' right to obtain records from the FTC that contained trade secrets. The district court denied the plaintiff's request for injunctive relief. In affirming that decision on appeal, the D.C. Circuit held that the public interest favored Congress having access to the records. The court stated that plaintiff's burden to obtain injunctive relief was considerably heightened by the clear public interest in maximizing the effectiveness of the investigatory powers of Congress. It would then require an extremely strong showing by the appellants to succeed in obtaining an injunction in light of the compelling public interest in denying such relief. The court concluded to grant the injunction appellate's request, this court would be required to interfere with the operation of Congress and also to depart from the traditional doctrine concerning the availability of equitable relief. The same would be true in this case. The court is well aware that this case involves records concerning the private and business affairs of the President of the United States. But on the question of whether to grant a stay pending appeal, the President is subject to the same legal standard as any other litigant that does not prevail. Plaintiffs have not raised a serious legal question going to the merits, and the balance of equities and the public interest weigh heavily in favor of denying relief. The risk of irreparable harm does not outweigh these other factors. The court, therefore, will not stay the return date of the subpoena beyond the 7 days agreed by the parties. For the foregoing reasons, the court will enter judgment in favor of the House Oversight Committee and against plaintiffs. The court denies plaintiffs' request for a stay pending appeal. A separate final order accompanies this memorandum opinion. May 20th, 2019, Judge Amit P. Mehta, United States District Judge, United States District Court for the District of Columbia. And thank you very much for joining me. My lawful masses. And that is our show. Take me to camera one. And that is our show, everyone. Thank you for joining me. We're going to take down our equipment in anticipation of a storm that we're about to have here. I will see you, I think tomorrow. We're going to do our Sunday show tomorrow. We still have to produce content for you for the week. Love you all. Oh, you know what? I do have something I forgot to do. I have one more page. One more page here. Thank you very much to our May 2019 supporters. You can support our channel on patreon.com/ljfrench or sponsors.org/u/lawfulmasses. Yeah, I'll just hold it. Thank you very much to our May 2019 supporters. You can support us on patreon.com/ljfrench or sponsors.org/u/lawfulmasses. Our May 2019 $50 per month supporters are John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, allquixotic, and Aspernari. Thank you very much for joining me today. I am Leonard French, your favorite copyright attorney. Thank you to John, thank you to Brandon, thank you, I assume Cerulean's there, thank you to Tactical, thank you to everyone else who helped today. Really made this whole thing possible. Love you all. I'll see you this week. Bye.